contract law, and you are under contract 2. Today, the topic that we are going to look at, misrepresentations. Misrepresentation, they are provided under section 12D, paragraph D of the Contracts Act 2010, as revised. Provided under section 12, paragraph D. So basically, under misrepresentation, basically in the layman, these are false statements that induce someone into what? Into a contract, basically. They are false statements that induce a party into a contract. Just as it was portrayed in the case of Fred Niwagaba versus Ande Musana Kaguma. Fred Niwagaba. That case court held that misrepresentation, these are false statements that induce someone into a contract. It must be a false statement and it must induce a party into a contract, basically. Not that in mind, basically, under the case of under the case of misrepresentation, they must induce a party into a contract, basically. Then to go further and bring in the element, a misrepresentation, basically, we have seen that these are statements that induce a party into what? A contract. But however, we have certain statements that do not amount to misrepresentations, as we are going to see. First of all, we have the statement of opinion. A statement of opinion can never induce a party into a contract. But however, it is just an opinion. You get? So, as anyone, that's why they say that you are entitled by your own what? Opinion. You are entitled by your own opinion. So meanwhile, even here, what you have to do is that your opinion cannot amount to a misrepresentation, since it is just a statement of what? Opinion. There's a case of Bissett versus Wilkinson. It was a statement that it was an opinion that this land can support 2,000 sheep. You get? But however, indeed, it didn't support, because the accused person took it as a misrepresentation. But however, court held that it was just a statement of opinion. You get? Just as it was also in the case of DeMarco versus Hallett, where they say that these were fertile soils and they were improvable. You get? It is just a statement of opinion. If I tell you that, if you use the other shortcut, you may reach early compared when you use the main road. If at all you use that shortcut and you don't reach early, I'm not entitled to a misrepresentation, because it was just a statement of what? Opinion. I was just giving my opinion. You either go by it or you leave it. Once you accept to go by it, which means at the end, you are on your own peril. You get? Then you also have a statement as to the future. A statement as to the future is that you give a statement. If I say that, this land following 2040 or 2050, it will be the most developed. It will have customers around, what and what. So that is a statement to the future. You get? If the future reaches and it is the contrary, I'm not entitled to a misrepresentation, because the law presumes that no one knows the future. Which means if I give a statement to the future, I'm not inducing you. Are either go by it or you live by it, because I'm not an oracle, I'm not a fortune teller. You get? So there is a case of Esso Petroleum versus Madon. Esso Petroleum versus Madon. Under this case, it was that petrol would reach 200,000 gallons in the third year of operation. But however, when the defendant used this statement and entered into a contract, it was false. But however, court held that was a statement to the future, which means the defendant was not liable under a misrepresentations. Then we have statements of law. The general rule under statements of law: ignorance of law is not a defense. If a statement is of a law, even if someone induces the other way around, so long as the statement was on the law, you get, it couldn't amount to a misrepresentation. For example, if I reach a morning and I say that the definition of a contract is under section 9, sorry, section 10, if I'm to misrepresent someone, is under section 10, and you write section 10, you say, oh, you lied to me. No, that is a statement of law. If at all it is section 9, you are entitled to know it. Ignorance of the law is not a defense, which means I didn't misrepresent you. That was a statement of law. You get. Then we also have silence. We have silence. Actually, before there's a case of Saul versus Butcher under statements of law. You get. It was about rate issues. You get. On the rate price, whereby it was around, it was about rent issues. I urge you to go and read it tentatively and verbatively. So we have silence. We say that silence cannot amount to a misrepresentation. What do I mean? If you come and you tell me something, but me I decide to stay silent, and if you take something in your presumption, even if me I didn't say yes, I didn't say no, I stayed silent, I didn't amount to a misrepresentation. If you take this pen, and at the end of the story, you tell me this pen, you start asking, does this pen work well? Yes, it works. You understand, you don't even give me time to answer. Yes, it works well, I see. So let me hope you have not lied to me. I say nothing. You reach there and you realize that the pen is not working. You cannot sue me for misrepresentation because I stayed silent and you took your own presumption, which you thought that it was true. You get. So silence cannot amount to a misrepresentation. There's a case of Smith versus Hodges. Smith versus Hodges. Hodges is Hughes. It was about the other one came to buy old oats for his horses, but didn't want the new oats because they were useless to him. So when he reached the shop, he even had a check. He checked. Then he said, these oats can work. These are old what? Oats. But reaching home after buying a certain sum of the oats, he reached and realized that the oats were new. So going back for suing for misrepresentation, the defendant stayed silent. So he couldn't sue for a misrepresentation because silence cannot amount to a misrepresentation. But however, there are exemptions to the general rule of silence. We are looking at silence only, whereby we are going to look for the circumstances where silence can amount to a misrepresentation. The general is silence cannot amount, but we are looking at the exemption where silence can amount to a misrepresentation. First of all, you have statements of half-truth. What do I mean by statements of half-truth? Basically, here you give part of the truth and you leave the rest. You get, that is a statement of half-truth. You don't reveal the whole truth of the scenario. You get, if at all, actually there is a case of DeMarco versus Hallett. It was that same case where they talked about statements of half-truth. Here, if in that case, this person disclosed half-length, disclosed that the land was fully lent to the tenants. But however, the tenants had served him a notice of intention to vacate the premises, which he didn't disclose. For him, he said that the premises were fully lent. But however, before, however much actually we know that the tenants were there, but they had given him a notice of intention to vacate. But for him, he just revealed that the land was fully lent. He didn't disclose. So that is a statement of half-truth. Then also read the case of Nottingham Brick and Tile Company versus Butler. Nottingham Brick and Tile Company versus Butler. Actually, what you have to know about half-truth, you are in a position whereby you know the whole truth, but you decide to reveal half of it and remain silent on the half of the rest, of which this half of the rest may be a misrepresentation once this person just follows or is induced by half of your truth. You get? So basically note that in mind. For example, if you are selling land and you know that there are bona fide occupants on the land and lawful, but you decide to say that the land is mine because the title is here, but you have not revealed to me that there are certain occupants on the land. Then you have the title, which makes you the legal owner, the owner, which is the truth, but it is half of it. The other half is that on that particular land, there are still bona fide and lawful occupants there, which we didn't reveal. So it amounts to a misrepresentation. Then another category, we have statements which become false. Statements which become false. Here, I'll give the example, a scenario whereby you approach a girl and you tell her you love her. That statement is true. But however, when you tell her that you love her, it is true, and it may be by then that you love her. But however, in the due process, the girl finds you with another girl. So the statement that you told her it was true, but it has later become what? False, which has amounted to a misrepresentation. I don't know whether we are on the same path. Statements which become false. I've given an example of a girl. You tell a girl that you love her, which is true, but later he finds you with another girl, maybe tomorrow or some other day. So the statement that you told her, it has become false. You get? There's a case of with versus O'Flogan. With versus O'Flogan, this was actually, it was the sale of a medical practice which was worth £2,000. £2,000. And the price, but however, the price had declined to £250. But this vendor, actually declined because of the vendor's inability to attend because of his illness. You get? Read the case of With versus O'Flogan. So it was a statement of truth which later became false because the inability there, it made it false, the price to become unrealistic. Then we have statements of utmost good faith. Statements of utmost good faith, which has the Latin word of uberi smafi deo, something like that. But they are contracts of utmost good faith. Statements that have a fiduciary relationship of care, trust, and confidentiality. Lawyers and clients, what and what. Yeah, that is contracts of utmost good faith, whereby you stand in a fiduciary relationship to disclose everything, every material fact. For example, you have the case of Joel versus Law Union and Crown Insurance. The defendant failed. It was about the breach of the duty of utmost good faith, whereby this person failed to disclose all the material facts while he was entering into an insurance contract. He failed to disclose all the material facts around the subject matter. You get? So he insured the property, but without utmost good faith. You get? So Joel versus Law Union and Crown Insurance Company. So basically, those are some of the exemptions as to the rule that silence does not amount to a misrepresentation. So we move to the types of misrepresentations. The types of misrepresentations, we have fraudulent. Fraudulent misrepresentation, as you hear the word fraud, we have fraudulent, we have negligent, and innocent. There are three. First of all, we have fraudulent. Fraudulent, basically, it means that something is false. You get? It is false, it is made under fraudulent, it is made in a way that is fraud. Actually, the elements there, when you read the case of Derry versus Pix, Derry versus Pix, actually that case of Derry versus Pix gives out the elements of fraudulent. Before, the facts of Derry versus Pix, this was a board that issued the document that they could use steam instead of horses, but they had not consulted the people that could issue them. So this person entered the contract in belief that he could use steam instead of horses. But after buying the company, when he applied to use steams, he was denied. So he sued the company for false representation. You get? So they gave three elements under false fraudulent misrepresentation. You issue a statement knowingly, you issue a statement without belief in the truth, you issue the statement recklessly, and carelessly. Those are the three elements under fraudulent. Then we have what they call negligent misrepresentation. Under negligent, we have like three principles under negligent. First of all, there must be a duty of care, there must be a breach of duty of care, and there must be a damage stroke injury to amount to negligence. You get. Under the case of Hadley Brain versus Hayler, this case portrayed what they meant by negligent misrepresentation. You had the duty of care, you breached that duty, which led to injury and damages. Under this case, these were Hadley Brain were advertising agents, and on behalf of ESO is a Power Limited. You get, we are advertising agent of is a Power Limited. So before they could issue an advert, they consulted the Hayler and the bank of is a Power, of which these people issued statements that were misrepresentations. You get, and as a result, it costed Hadley Brain, the advertising company. So they sued for negligent misrepresentation that were made by Hayler, the bankers, and the managers of what? Of Easy Power Limited. Then we have innocent. Innocent misrepresentation, as you hear the word innocent, you issue a statement out of innocently. Let me give an example. If you are the class captain or the class coordinator, the lecturer calls you and tells you that, you know what, I'm coming to class. Tell the members to be available. As the class coordinator, you come to the members, you tell them, you know what, the lecturer said is what is coming. But unfortunately, the lecturer doesn't come. So if the class sues you for misrepresentation, you fall under the category of innocent misrepresentation, because even you were it was the lecturer that told you, and you issued a statement innocently. You get. So yeah, that case also had the Brain versus Hayler. It also brings out that element of innocent misrepresentations. Then we have also remedies under misrepresentations, damages, indemnity, and rescission. You get. The remedies, we have rescission. Rescission, that's basically taking the parties to their original state, where they were, to their original state. That if I sold you this pen, give me my pen and I give you your money, just the original state. Then damages, that is the costs that you incurred, the losses, among others. Meanwhile, even indemnity, you have had war indemnity, the issue for the damages that you incurred while adjusting to the contract. So basically, that's the essence. But other than that, thank you for listening and thank you for watching.